My name is Renata Voss. I'm 34 years old. And the morning I drove past Franklin Addo's office and saw my mother's car in the lot beside my brother's was the morning I finally understood that some families do not cut you out of things because they have decided you do not matter. They cut you out because they have decided for so long and so comfortably that you will simply absorb it, that the years of driving to appointments and managing the forms and holding the records and keeping the piece of paper they do not know exists will continue to accrue to the family without requiring the family to account for them. That you will absorb all of it, as you always have, and that this will be the end of the matter. The letter had arrived 3 days before. It came by email, addressed to my brother Owen and forwarded to me, I think by accident, though I have never been certain, with a subject line that read, Estate of Margaret Voss, Family Meeting, Friday 9 a.m., Addo Law. The body of the email said immediate family only. All relevant parties should be present. Owen had been CC'd on the original. I had not. I printed the email. I added it to the fireproof document box I kept in the trunk of my car, behind the spare tire, in the particular way of someone who has worked in forensic accounting long enough to understand that the documents you preserve without knowing why are often the ones that matter most. The box already held 47 printed emails and a certified copy of a trust document my grandmother had filed with Franklin Addo's office 3 years before she died. I had been keeping those documents for 18 months. I had not told anyone I was keeping them. On Friday morning, I drove to work along my usual route, which took me past Addo Law on the corner of Mercer and Broad. I saw my mother's sedan and Owen's truck in the parking lot. I noted the time, 9:04 a.m. I drove another 3 blocks to the parking garage, took the elevator to the 6th floor, sat at my desk, and opened the forensic analysis I had been working on for a municipal procurement case. I worked for 6 hours. What none of them knew, not my mother Dorothea, not my brother Owen, not Franklin Addo, who had been the family's estate attorney for 20 years, was that the trust they were meeting to administer was not the trust they believed it to be. The document my grandmother Margaret had executed and filed in the spring of her 81st year was not the earlier version that my mother had a copy of. It was a revised trust, prepared by Franklin Addo himself at my grandmother's direction and notarized by his office, that named me as co-trustee alongside my mother and allocated 40% of the estate's assets to me as a named beneficiary. My grandmother had not told my mother about the revision. She had told me, on a Tuesday afternoon in her kitchen while I was sorting her medications into the weekly organizer, quietly and without ceremony, the way she did most things that mattered. That Tuesday conversation was 2 years and 4 months before the Friday morning I drove past the parking lot. I want to explain what those 2 years and 4 months looked like because the ending is unintelligible without them. I have worked as a forensic accountant for 8 years. My firm handles financial investigations, fraud analysis, asset tracing, disputed estate valuations, procurement irregularities for municipal and corporate clients. The work requires a quality that my supervisor, Dana Briggs, once described in a performance review as disciplined patience, the capacity to sit with incomplete information across a long timeline without drawing conclusions before the evidence supports them, and without discarding evidence because it does not yet appear to fit the picture you expect. You collect. You file. You wait for the pattern to declare itself. Dana has been doing forensic work for 22 years, and she uses disciplined patience the way other people use the word instinct, as shorthand for something that cannot be taught directly but that can be recognized, without ambiguity, when you see it in a person. I have had it since I was a child. My family is not large. My mother Dorothea is 61, the youngest of 2 sisters, the one who stayed close to home after my grandfather died. My brother Owen is 37, 3 years older than me, easy in rooms in the way of people who have been told their whole lives that they are good company. My grandmother Margaret, my mother's mother, was the person around whom everything else in the family organized, not by authority in any formal sense but by gravity, by the particular weight that accumulates in a person who has been present and watchful and honest for 83 years and who becomes, over time, the thing everyone orbits. My father left when I was 9. This is not the central fact of this story, but it is a relevant one, because his departure reorganized the family's operating logic in ways that lasted for decades and that no one ever named directly. My mother had raised 2 children largely alone. She had done it with the help of her mother and her own considerable competence, and she had done it well, and somewhere in the years that followed the departure, she had arrived at a position she held firmly. She had carried the weight, and Owen and I owed her a certain deference for that, and any difficulty I introduced into the family structure was, by definition, an ingratitude. This was not a stated position. It was an atmospheric one, the kind of understanding that does not require articulation because it has been present long enough to feel like weather. You do not discuss the rain. You simply account for it. Owen had no difficulty. He called and came to dinners and remembered birthdays and had a gift for being present in the ways that did not require inconvenience. He was warm and easy and my mother's clear preference, not through any stated favoritism, nothing so crude as that, but through the accumulated habit of a current that runs in one direction long enough that no one questions its direction anymore. Owen made my mother feel seen. He had always been good at that. He brought the emotional energy she needed, and he did not bring complications, and in her accounting, emotional presence and the absence of complications were the primary currencies. I want to be fair to Owen, because this story is not about Owen as a villain. He is not one. He is a man who grew up in a family system that allowed him to be present without cost and who accepted that arrangement without examining it, which is a failure of a particular kind but not a malicious one. He genuinely loved my grandmother. He genuinely loves my mother. He was at the holiday dinners and the Sunday calls and important occasions, and he felt, I believe, that he was doing his part. He had simply never had to think carefully about what the other parts were. I was the other kind of there. I was there when the furnace broke and someone needed to coordinate the repair and wait for the technician and follow up when the part didn't come in on the first promised date. I was there when my grandmother's first cardiologist retired and someone needed to research replacements, not just find one but evaluate the options against her specific cardiac history, call the insurance company to confirm coverage, and manage the transition of records. I was there when my mother's taxes became complicated enough that she needed someone to sit with her accountant and understand what he was explaining. I was there for the things that required knowledge and follow-through, and the willingness to navigate institutional processes that most people find tedious and that I find, if I'm honest, not tedious at all. Forensic accounting is, at its core, the discipline of treating complex information systematically until it reveals what it contains. I had been doing that in my own way, in my family long before I understood that it was a profession. These forms of presence are invisible in the way that functional systems are invisible. You only notice the furnace when it stops working. You only notice the medication schedule when it is missed. When the house is warm and the appointments are coordinated and the insurance claim is resolved, no one is aware that any of it required labor, because the labor succeeded in making itself undetectable. This is the fundamental economics of competent maintenance. It removes itself from view precisely because it works. I had understood this dynamic in my family for years, and I had not required it to change. I was not building toward a confrontation. I was not assembling a case for an argument. What I had done quietly and without making it a production was maintain my own record, a private accounting of what the structure of our family actually was, as distinct from what the story we told about it implied. My grandmother knew this about me. She had watched me long enough to see it clearly. She was, in this way, the one person in my family who understood what I was doing and what I was, and she had understood it for years before she asked me to come inside. My grandmother began to require more management in her late 70s. Not dramatically, the gradual accumulation of health complexity that is more demanding than a crisis because it has no fixed end point and no resolution you can point to. Medications multiplied, each with its own schedule and its own set of interactions to monitor. Specialist appointments proliferated: cardiologist, endocrinologist, a physical therapist after a fall in the winter of her 79th year, a neurologist the following spring when her primary care physician noted some word-finding delays that warranted a formal investigation. The house on Elm Ridge Road, a large colonial she had owned since 1974, needed more attention than she could give it alone. The garden she had kept for 40 years had grown past what she could safely manage. The cottage at the back of the property had been built in 1999 for visiting family. It was fully equipped, a small kitchen, a living room, 2 bedrooms, a bathroom, and it had been used intermittently for years but had sat empty for the 2 years before I moved in. My grandmother mentioned once in passing that it was there and that it was available. She did not ask directly. That was her way. She made information available and let you draw the conclusion she was offering, without the friction of a request. I drew the conclusion. I was renting an apartment 20 minutes away. The commute from Elm Ridge Road to my office was 27 minutes, 4 minutes longer. The cottage was larger than my apartment and significantly quieter. I told Dana Briggs I would occasionally need flexibility for medical appointments. She said that was fine. I set up my home office in the cottage's second bedroom, transferred my lease deposit to my moving fund, and was living on Elm Ridge Road by the end of October of my 29th year. I want to be specific about what the next 5 years looked like because this story is not about abstract devotion. It is about a specific quantity of labor performed over a specific period of time. I attended 41 medical appointments across 5 different specialists: cardiologist, endocrinologist, neurologist, physical therapist, and a geriatric psychiatrist. My grandmother was referred to in her 82nd year when her general practitioner wanted a baseline cognitive assessment. I drove her to 37 of the 41 and made arrangements for the other 4 when work required it. I maintained a medication log, current prescriptions, dosages, scheduling notes, interactions to watch for, pharmacist contacts, that I updated after every appointment and shared with each treating physician and with the home care aides in the final months. My grandmother's primary care physician, Dr. Amara Osei, told me at the end of my 3rd year in the cottage that the log had caught a dosage interaction between 2 newly adjusted prescriptions that could have caused a significant cardiac event. She said it with the quiet weight of a physician acknowledging something that mattered. I noted the date of that conversation in my log and filed the note. I managed 3 separate insurance claim disputes. The first 2 required written appeals and follow-up correspondence, one concerning a disputed billing code on a specialist visit, one concerning a denial of a prescribed medication that was eventually overturned after I submitted a clinical necessity letter from Dr. Osei. The third required a phone escalation to a supervisor at the insurance company's appeals department, a woman who initially declined to review the claim and whom I spent 40 minutes with on a recorded line, walking through the relevant policy language clause by clause, until she agreed to submit it for formal review. The claim was approved 6 weeks later. The reimbursement covered $8,400 in care costs that my grandmother had been paying out of pocket because the appeals process had been too cumbersome for her to navigate, and no one in the family had been doing it for her until I did. That money had come out of the same estate that was later the subject of the trust revision, and it had come out of it unnecessarily. I recovered it. I filed the correspondence. I coordinated with a home care agency for the final 14 months. I interviewed 4 agencies before selecting one, reviewing their licensing status with the state board, their staff turnover rates, their complaint history, their age training documentation. I reviewed the assignment schedule monthly and filed 2 formal complaints that resulted in aid reassignments, once for a documentation gap in the medication administration record, and once for a pattern of behavior I had directly observed during a visit that concerned me. Both complaints were addressed promptly. Both resolutions were documented. Mrs. Poletti, who had watched me arrive and leave from the cottage for 5 years and who brought soup to my grandmother twice a week in the final months, told me once that she had never seen a family caregiving situation managed with such consistency. I said I had not been doing it alone. She looked at me with the particular expression of someone who disagrees and has decided there is no productive path through the disagreement, and she left it there. I noted that expression too. I have thought about it many times since. I handled my grandmother's tax returns for 4 of the 5 years, working with her longtime accountant Raymond Keyes. Raymond is a meticulous man who has been practicing for 30 years and who told me twice that I had caught errors he had missed. The first was a misclassification of a dividend distribution. The second was a missed deduction on qualifying medical expenses that resulted in a refund of $2,300. I filed both corrections and kept copies of the correspondence. Owen visited on holidays and called on Sundays. He was warm when he was there, genuinely warm, the warmth of someone who loves the people in the room and is present when present. He brought things, food from the restaurant on the avenue that my grandmother liked, flowers, news from his own life that she enjoyed hearing. He sat with her. He was not performing. He simply did not see the systems, because the systems worked, and invisible systems are invisible in direct proportion to how well they function. My mother came every other weekend. She was not absent. She sat with my grandmother, brought groceries, managed the warmth and continuity of the visits in the way she has always been good at. What she did not do was manage the appointments, the medications, the insurance claims, the home care schedule, the tax returns, the maintenance requests on the main house. Neither of us named this. The naming was not necessary because the structure operated on its own. In the spring of my 3rd year in the cottage, my grandmother asked me to drive her to Franklin Addo's office. She had an appointment to review some estate matters. She asked me to come inside. She had not asked me to come inside for any previous estate appointment. I had driven her to 2 of them and had waited in the car both times. I followed her in. The revision she had directed was substantive. The 2016 amendment had named my mother as sole trustee and divided the estate, valued then at approximately $412,000, including the Elm Ridge Road property and investment accounts, between my mother and Owen in equal shares. The revised document named me as co-trustee alongside my mother and allocated 40% to me as a named beneficiary, reducing the remaining shares proportionally. My grandmother explained her reasoning to Addo in the same direct way she explained most things. She said she had a person who had been managing the practical work of her life for 3 years and who would continue to do so, and she wanted the document to reflect that. She said she did not want me compensated after the fact as though the work had been a transaction, but that she had not found a way to honor it during her lifetime that felt right, and this was the most honest thing she could do with what she had. Addo prepared the revision. His notary witnessed and sealed it. My grandmother signed. I was given a certified copy before we left. She said, in the car on the way home, that she had not told my mother. She wanted the document in place first. She trusted me to hold my copy carefully. I said I would. We stopped for lunch at the sandwich shop on Route 9 that she had been going to since I was small. She had what she always had. We did not speak about the document again, and she died 14 months later before she had told my mother, and the document was exactly where she had asked me to keep it. The revision my grandmother had directed was substantive. Franklin Addo had prepared the original trust in 2011 and updated it once in 2016, at which point it had named my mother as sole trustee and divided the estate, the Elm Ridge Road property, its contents, and the investment accounts she had maintained since my grandfather's death, between my mother and Owen in equal shares. The revised document named me as co-trustee alongside my mother. It allocated 40% of the estate's assets to me as a named beneficiary, reducing my mother's and Owen's shares proportionally. The change was specific and documented and reflected, in my grandmother's own stated reasoning to Franklin Addo, the actual structure of her care over the preceding 3 years. She said it plainly, in the way she said most things. She had a person who had been managing the practical work of her life and who would likely continue to do so, and she wanted the legal document to reflect the actual arrangement. She said she did not want me compensated after the fact as though the work had been a transaction, but that she had not found a way to honor during her lifetime that did not feel awkward, and this was the most honest thing she could do. I want to be accurate about how I felt in that room because I think it matters to the story. I did not feel vindicated. I did not feel that a wrong was being corrected because the wrong had not yet occurred. My grandmother was still alive and the estate had not yet been subject to any dispute. What I felt was something closer to recognition, the particular quality of being seen accurately by someone whose opinion you have valued for your entire life, with a notary present and a legal document on the table. My grandmother was not making a statement to the family. She was making a record. She understood, with the same clarity she brought to most things, that the record would eventually matter more than the statement. She had been watching our family long enough to know that. Franklin Addo prepared the revision. His notary witnessed it. My grandmother signed. I was given a certified copy before we left. She said, on the drive home, that she had not told my mother. She said she would, in time, but that she wanted the document in place first and some distance before the conversation. She said she trusted me to hold my copy carefully. I said I would. We stopped for lunch at the sandwich shop on Route 9 that she had been going to since I was small. She had the same thing she always had. We did not discuss the document again. She died 14 months later, on a Thursday in October, before she had told my mother. My grandmother's death arrived the way deaths that have been given adequate time to approach arrive, not without wait, but without surprise. The home care aide called me at 6:40 in the morning. I called my mother, then Owen. I called Dr. Ose's office, the funeral home my grandmother had specified in a document she had given me 3 years earlier, and the pastor. I handled these calls because I was the one who knew the names and the numbers. That is how it had been for 5 years, and it was how it was on the Thursday in October that it ended. Owen arrived from 2 hours away by noon. My mother had been there since 8. The funeral was a Tuesday. Mrs. Poletti held my hand at the reception and said she did not know how I had done it. I said I had not been alone. She looked at me the way she had looked at me before on that subject. In the days after the funeral, my mother began mentioning Franklin Addo's name. She had scheduled a meeting, she said. She would let me know. She did not let me know. The email arrived 18 days after my grandmother died. Family meeting. Immediate family only. Friday, 9 a.m. I want to be specific about the 18 months before that email because they are the reason I had a fireproof document box in my car trunk and why that box mattered. On the afternoon I drove home from Franklin Addo's office with the certified copy of the revised trust. I did 2 things. The first was immediate. I stopped at an office supply store on the way home and bought a fireproof document box, metal, lockable, sized to hold a standard hanging file, and when I got home, I placed the certified copy inside along with my own closing documentation from the apartment lease and sealed the box. I put it in the back of my closet behind a storage bin, where it was not visible from the door. The second thing I did was less concrete but more sustained. I began paying a different kind of attention. I had always paid careful attention to my family. That was the particular education I had received growing up in it. But the attention I began paying after that Tuesday in Franklin Addo's office was of a different quality, more systematic, more documentary in its impulse. I started keeping a log. Not a dramatic document. A simple dated record. What was said, what was communicated, and what was notable by its absence. When my mother mentioned Franklin Addo in a phone call, I logged the call, the date, and what she said. When I was copied on an email regarding the estate, I printed and filed it. When I was not copied on what I understood to be an estate-related communication, I noted the omission. This is, in professional terms, what is called building a contemporaneous record, a running account of events documented at or near the time they occur, which carries evidentiary weight precisely because it is not assembled after the fact for a specific purpose. I knew this from my work. I applied it here because I understood, with the particular clarity of someone trained to read financial documents, that the trust one was holding was the kind of document that does not survive if the people who want it to disappear know it exists and have access to the copy. Over 12 months, I accumulated 47 printed emails. The first batch were emails about the estate that I had been copied on, conversations between my mother and Owen about Addo's fees, the preliminary inventory of my grandmother's assets, the question of what to do with her furniture, and personal effects. I had been included in these conversations in the early months after my grandmother began her decline, when the practical logistics required more hands. As the months passed and the formal estate planning conversations became more specific, the inclusion became intermittent and then stopped. I kept every email, including the ones sent to me and the ones forwarded to me and the ones I received as accidental copies. I kept the voicemails my mother left about estate matters, 3 of them in the 14 months after the trust revision, each touching on the house or the accounts or the process, without including me in the decisions they were advancing. I moved the document box from the closet to my car trunk 10 months after I had first put it away, after I came home one afternoon to find that my cousin, staying briefly in the main house while renovations were done on her apartment, had used my home office and left my closet door ajar in a way that told me she had been in it. Nothing was missing, but I understood the vulnerability. My home office was accessible to anyone with a reason to be in the cottage. My car trunk was not. The box was with me after that. Every day. It was in the trunk when I drove to work and when I drove to my grandmother's appointments and when I drove to family dinners and when I drove past Franklin Addo's office on a Friday morning at 9:04 in the morning and saw the cars and kept going. I also retained Sylvia Park. This happened 8 months after the trust revision, after I had identified her through a professional referral, a colleague in my firm who had used her for an estate matter and described her as the kind of attorney who tells you what is true rather than what you want to hear. I paid her for a 1-hour consultation. I explained the trust revision, the family structure, my assessment of the likely scenario, and my current documentation status. She asked 7 questions, all of them precise, none of them unnecessary. At the end of the hour, she said, "Keep the certified copy somewhere your family cannot access. Document your caregiving in as much detail as you can. Keep contemporaneous records of all estate-related communications. Call me when the time comes." She did not ask why I was anticipating a problem. She was a probate attorney who had been practicing for 18 years. She understood the shape of the situation from the first 3 minutes of the conversation. I paid her invoice the same week. I filed it in the document box. Over the following months, I continued building the record. Medical appointment receipts, insurance correspondence, the home care agency's monthly schedules with my annotations, Raymond Keyes's acknowledgement that my corrections to my grandmother's tax returns had been accurate, 2 emails from Dr. Amara Osei referencing the medication log and its role in identifying the dosage interaction. I was not building a case. I was building a record. The distinction, to me, was significant. A case is assembled toward a specific argument. A record is maintained because the events it documents happened and deserve to be documented. The argument, if any, would emerge from the record if and when it was needed. I did not know in advance whether it would be needed. I knew what my grandmother had decided. I knew what the document said. I knew what a careful record of what actually happened looked like. When the email about the family meeting arrived, I printed it and put it in the box. When I drove past the parking lot on Friday morning, the box was in the trunk. I called Sylvia Park from my office at noon. I told her the meeting had taken place without me that morning and that the family had proceeded with the estate administration using the 2016 document. She said she had expected that. She said she would contact Addo's office the following week to arrange a meeting and that I should expect his assistant to call within 10 days. The call came in 6 days, to my work number. Addo's assistant asked me to come in at my convenience regarding the estate of Margaret Voss. I called Sylvia. We scheduled for the following morning. I want to describe that meeting with care because it was the first room where the document moved from being something I carried to being something that had legal weight outside of me. We arrived at 9 o'clock. Addo's office had the established quality of a firm that had been in the same space for 20 years, bookshelves with actual books, a conference table that had held many difficult conversations, the particular tidiness of an office whose assistant has been there as long as the attorney. Addo himself was in his late 50s, methodical and careful, the kind of professional who reads documents line by line and does not summarize. He had, I thought, the particular quality of someone who already knew what the meeting was about before we sat down. Sylvia placed the certified copy of the revised trust on the table. She did not speak before she placed it. She let it sit for a moment. Addo's assistant retrieved his firm's file copy from the archive. Addo reviewed both documents in sequence, not quickly, thoroughly. He confirmed the execution date. He confirmed the notary certification against his own records. He confirmed the beneficiary allocations and the co-trustee designations. He took approximately 12 minutes to do this. The room was quiet while he worked. When he finished, he said, in the precise and slightly formal language of an attorney acknowledging a material fact he should have caught earlier, that the revised trust was the operative document for the estate of Margaret Voss. He said he had been under the impression that the 2016 amendment was the most recent version of the trust. Sylvia said her client understood that to have been his working assumption. He said the family meeting on Friday had proceeded without awareness of the revision. Sylvia said that was consistent with her client's understanding. He said he would need to notify the relevant parties of the operative document. Sylvia said her office would handle the formal notification. I had not spoken since we sat down. I had placed the stack of 47 printed emails on the table at the start of the meeting, without explanation or annotation. Addo had looked at the stack when I put it down. He had not asked what it was. He had looked at it the way an attorney looks at a document pile that tells him something about the preparation that went into the meeting he is now sitting in, and he had moved on. He asked whether there were questions. Sylvia said we would be in contact about the probate timeline. I thanked him for his time. We left. In the elevator going down, Sylvia said, "He knew about the revision. He has to have known. He prepared it." I said I thought so too. She said, "He didn't surface it because no one asked him to." I said that was consistent with my assessment of the situation. She said, "Now someone has asked." My mother called me the same evening she received Sylvia's certified letter. Her voice had the quality of someone who has been sitting with information for 3 days and has not yet finished the work of sitting with it. She said my name the way people say a name, when they're not sure what else to say after it, but need to begin somewhere. She said she had received Sylvia Park's letter. I said yes. She said she did not understand why I had not simply come to the meeting. She said they could have handled it as a family. She said as a family twice in the first 2 minutes, the phrase with a particular emphasis as though the category itself was the argument. I noted it each time without responding to it. I said the meeting had been described as immediate family only and that I had not been included in the scheduling. She said that was an oversight. She said Owen had forwarded the email. She said they had assumed I knew. I said I had received the forwarded email. I said I had driven past the office on Friday morning at 9:04 and seen my mother's sedan and Owen's truck in the lot. I said I had kept driving. The pause that followed was the particular pause of someone revising a version of events they had been holding for 3 days. I have learned to recognize that pause in professional contexts, the interval between when a person understands that their account of a situation does not match the available evidence and when they decide what to say next. She said, "You saw us there." I said yes. She said, "And you kept going." I said yes. She said, after a moment that took the full weight of itself, "Why?" I said, "Because I had an attorney and the original document and a complete record of 18 months of communications." I said the right moment to use those things was not a meeting I had been excluded from. I said those things were not the same as retaliation. They were what preparation looks like when you have been careful. I heard her draw a breath that was not quite steady. She said, "You've been planning this." I said I had been prepared. I said those were different. Planning implies a specific desired outcome. Being prepared means you have what you need regardless of how things develop. I said I had not known, when I started keeping the documents, what the outcome would be. I had known what my grandmother had decided, and I had wanted the legal record to reflect that correctly. That was what I was prepared for. She said she needed to talk to Owen. I said I understood. I said Sylvia Park would be in contact regarding the probate timeline and process. And then, because I think she had prepared to have a shorter conversation, and because the 3 days had done some of their work, she stayed on the call. We were on the phone for another 12 minutes, and the conversation moved through several registers, some of them harder than others. I will not narrate all of it, because some of what was said was between my mother and me and belongs to us. But I will say this. At some point she stopped using the phrase as a family as an argument. She shifted from a position to something more like a question. She asked whether I had felt this way for a long time, the way of being the one who absorbed the practical weight of the family without being seen inside it. I said I had not been looking for acknowledgement. I said I had been looking for accuracy. I said those two things are different, and the difference matters to me, and I wanted her to understand that I was not trying to punish her or the family. I was trying to make sure the legal record matched the actual structure of what had happened. She was quiet for a long time. Then she said my grandmother's name. She said she had not known the trust had been revised. She said it plainly as a fact, not as a defense. I said I knew. I said that had been my grandmother's decision. What to tell, to whom, and when. I said I had honored that decision by keeping the document where she asked me to keep it and waiting for the right time and the right room. My mother said, very quietly, she knew what she was doing when she asked you to come inside. I said yes. I said she always had. She said, I think I knew I hadn't been fair to you. I think she knew I knew. And I think she made the document before the conversation because she understood the conversation might not happen in time. I did not say anything to that. There was nothing I needed to add. She said, "That's a hard thing to live with." I said, "I know." We said goodnight shortly after. The probate proceeding was set 14 months after my grandmother's death. That timeline reflected the usual complexity. The operative trust document question required extended back and forth between Sylvia Park and Addo's office, then between Sylvia and the attorney my mother retained to review her position, a man named Gerald Fitch who had, according to Sylvia, concluded early in his review that the document question was settled and that contesting the revision would not benefit anyone involved. She described him as a careful attorney who had told his client the accurate thing, which she said was not as common as it should be. The 14 months between the email I had printed and put in the box and the morning of the hearing were not idle months. They were months in which Sylvia filed the petition, in which Addo's office provided its file, in which Gerald Fitch reviewed the notary records and the execution timeline and apparently reached the conclusion Sylvia had said he would. They were months in which my mother and I had the phone call I described and several others, and in which the conversations moved by degrees from formal to honest. They were months in which Owen and I had dinner once, in February, at a restaurant neither of us had suggested, which his wife had apparently arranged. She is a pragmatic and perceptive woman who understood that the dinner needed to happen and that neither Owen nor I would schedule it independently. The dinner was not easy and not terrible. Owen said things that mattered and some that didn't, and I said the same, and by the end of it we had established a different floor, lower in some ways, more solid in others. The hearing was a Wednesday morning in mid-November in the county probate court downtown. The building was a municipal structure from the 1960s, well-maintained in the way of public buildings where the maintenance budget is adequate, but the aesthetic ambitions are modest. The courtroom itself had fluorescent lighting and wooden gallery benches worn from decades of use, the particular institutional quality of rooms that exist for serious and undramatic business, where the point has never been the setting. Judge Carol Weston had been on the probate bench for 11 years. She was thorough and unhurried, and had the manner of someone who has reviewed a great many trust documents and finds them, consistently, to say exactly what they appear to say. She was not a judge who performed her authority. She had it, and used it the way people use things they have had long enough to be comfortable with. My mother and Owen sat at the respondents' table with Gerald Fitch. I had not been in a room with my mother since 3 months before the hearing. We had spoken by phone and text, and the conversations had moved towards something more honest than where they started, without having arrived anywhere fully resolved. I had attended the dinner with Owen in February. The situation had not clarified into anything clean, but it had clarified, and I understood that clarity at this speed was the kind I trusted. I sat at the petitioner's table with Sylvia Park. My certified copy of the trust was in my bag. The fireproof document box was in my trunk in the courthouse parking structure 2 levels below us. I had not needed to bring it in. Sylvia had the relevant copies, and the court had the file. But I had wanted it nearby, in the way of someone who has carried a thing for long enough that its presence is itself a form of steadiness. Judge Weston reviewed the documents in sequence. She was methodical in the way of someone who does not take shortcuts, not because shortcuts are not available, but because they are not worth the risk. She confirmed the 2011 original, then the 2016 amendment. Then she confirmed the revision, execution date, notary certification, witness records. She noted for the record that no challenge to the validity of the revision had been filed with the court in the period between its execution and the current proceeding, and that the document had been properly maintained in the firm's file. Then she read the provisions aloud. Her voice was even and official and carried no theatrical quality in either direction. She read the trustee designations. The trust names Dorothea Voss and Renata Voss as co-trustees. She turned a page. She read the beneficiary allocations, my mother's name, Owen's name, and mine. When she reached Renata Voss, 40%, she read it in the same even official register she had used for every other line. She did not emphasize it. She did not need to. Across the room, my mother's hands, which had been resting flat on the table, went still. Owen looked at the table surface. Gerald Fitch had a pen in his hand, and was not using it. The room held its breath for the duration of 2 sentences before Judge Weston continued to the administration instructions. She was not aware of holding the room. She was simply reading, as she had been all morning. Judge Weston confirmed the trust's validity, instructed the parties on the timeline for administration, outlined the reporting requirements, and asked whether there were questions. There were none. The proceeding had lasted 31 minutes. The clerk filed a confirmation order before we left the building. In the lobby, Sylvia confirmed the Hugh-Nair notification and the administration timeline. At the courthouse door, she said, "You were very patient." I said it had been the right approach. She said most people could not hold that long. She said it with the quiet certainty of someone who has watched many people try. I walked to the parking structure. The box was in the trunk where I had put it. I drove to work. I had a procurement analysis due by end of day. The estate administration closed 9 months after the probate hearing. My share of the $412,000 estate, 40%, was $164,800, distributed by Hugh-Nair at the trust department on a Thursday afternoon. I received the wire notification at my desk. I read it, filed it, and went back to the analysis I had been working on. Dana Briggs stopped by at 4. No agenda. She asked how I was doing. I said it had been a productive week. She said good. We went back to work. The months between the hearing and the close of administration had their own settling quality. My mother and I spoke more honestly as the months passed, not about everything at once, but incrementally, the way trust adjusts to new information over time. She asked me once, 8 months after the hearing, whether I had known she would react the way she had. I said I had anticipated the exclusion. I said I had not built my response around her reaction. I had built it around the document and the legal process, and her reaction was something that would have to be what it was. She said, "I think I knew I hadn't been fair to you. I think she knew I knew. And I think she made the document before the conversation because she understood the conversation might not come in time." I had heard her say this on the phone the night she called. Hearing it again, 8 months later, with time between us, it was different. It was something she had sat with and returned to. I said I knew. She said, "That's a hard thing to live with." I said, "I know. I think she knew it would be. I think she decided the document mattered more than the comfort." Owen and I are in a different place now than we were, better, but still finding the shape of it. He told me once that he had not thought, during those 5 years, about what I was doing in the cottage in any way that required him to think. He said it without defensiveness, as an accurate description of a failure. I said I understood how the system had worked. Invisible systems stay invisible unless someone stops maintaining them. He looked at the window. We are closer to honest than we have been. That is the direction that matters. The estate is settled. The cottage and the main house on Elm Ridge Road were sold as part of the distribution. I moved out 6 months after my grandmother died, when it became clear the property would need to be listed. I did not drive past Elm Ridge Road in the months after the sale. Mrs. Poletti, who had bought a house 2 streets over, sent me a photograph from one of her walks. The Japanese maple by the side door, now fully established, the canopy wide. I kept the photograph in my records folder, beside the estate distribution letter. The fireproof document box is in my current car's trunk. It holds fewer things than it once did: the certified copy of the trust, the estate distribution letter, 3 pages of the probate record. I do not know that I will need them again. I keep them because the box is a record of a period when I carried something carefully for a long time and handed it to the right person at the right moment. That is worth keeping. Dana Briggs would call it disciplined patience. She would be right. I have been practicing it my whole life. I did not know, until a probate judge read my grandmother's revised trust aloud in a county courtroom on a Wednesday in November, what it had been building toward. Now I know. Some people, when I have told them parts of the story, ask about the morning I drove past the parking lot. They ask what it was like to see the cars there, and keep going. They expect it to have been a difficult moment, a test of something, a choice that required significant effort. It was not. It was the logical consequence of 18 months of preparation, meeting the moment the preparation was for. I had the document. I had the attorney. I had the record. The right time and the right room were not that parking lot on that Friday morning at 9:04 a.m. Driving past was not restraint in the dramatic sense. It was accuracy, That was not the right place to use what I had, and I understood that without having to reason through it, the way you understand a thing when you have been preparing for it long enough that the preparation becomes instinct. Dana Briggs would call this disciplined patience. She would be right. I have been practicing it since I was a child, sitting at the kitchen table in my mother's house, watching the family operate, learning to observe carefully and hold what I observed until the observation became useful. That particular education did not feel like education at the time. It felt like being the kind of child who notices things and keeps them to herself because there is no obvious other place for them to go. I did not know until many years later that it was also a professional skill and that it would eventually be the thing I was known for at work. I did not know until a probate judge read my grandmother's revised trust aloud in a county courtroom on a Wednesday in November that it would be the thing that mattered most at home. My grandmother understood something about me that I had not fully articulated to myself. She understood it before I did, with the clarity of someone who has watched a person closely for decades and who knows, without needing to ask, what they are capable of when the situation requires it. She asked me to come inside because she knew I would understand what the document was, would understand why she was making it, and would hold it correctly until the right moment. She was right about all three of those things. She was also right that the moment would come, that the family's operating logic, left unexamined, would eventually require the document to speak. It spoke. Judge Weston read my name from the page on a Wednesday morning, in a courtroom with 7 people in it, in the even official voice of someone doing her job correctly. The room went still for the duration of 2 sentences. I sat with my hands on the table and let her finish. The estate is settled. The property is sold. The distribution is complete. The document that my grandmother signed in Franklin Addo's office in the spring of her 81st year is filed in the county probate record, where it is part of the permanent account of what she decided and why. I still have my certified copy. It is in the fireproof document box, which is in the trunk of my current car, behind the spare tire. The box holds fewer things than it once did: the trust, the distribution letter, the key probate documents. I do not know that I will need them. I keep them because that is how I work, and because there was a period when the box was the most important object I owned, and certain habits form around the things that mattered when they mattered most. What you hold with care long enough will eventually be read aloud. The question is not whether. The question is whether you will still be in the room when it happens, with the document you were asked to keep, in the chair you earned by showing up. Here is what I find myself returning to, the question I cannot fully answer on my own. In that courtroom, when Judge Weston read the co-trustee designation and the allocation and my name, there were 7 people in the room besides the judge. I watched what happened to the air when she finished reading, the particular stillness that settles over a room when a document says something that changes the shape of what everyone thought they knew. Have you ever been in a room like that? Where a piece of paper said something that altered what was true? Where the record corrected what everyone had already decided? What is it like to be in that room, on either side of the table? If you have, I would like to hear about it in the comments. Subscribe for more stories like this one. A new story posts every Thursday. I will see you there.